to avoid liability is to make sure you comply. Is there some reason, our staff were briefed this morning about the Kramer-Levin review, which I guess you were referring to when you said that the allegations put forward by Mr. Kulczynski were investigated and found to be baseless. Although it's my understanding that A, that review is not complete, and that B, the entirety of this review will be oral. It will not be put in writing. Is there a reason for that?
We discussed earlier the communications around and documentation around that investigation. I will communicate the wishes of this committee to our legal counsel, and I expect they will be able to comply with any request that comes from the committee.
Well, that's really not my question. Is there a reason why? I mean, this strikes me as quite unusual that a review of charges of fraud by your outside counsel would, in fact, not be in writing, and apparently Kramer-Levin indicated it's not going to be put in writing.
I'm not familiar with whether there will be a written report or not.
Are you familiar with the fact that it is or is not the practice of Moody's to give such instructions to outside counsel?
I'm not familiar with the instructions that we've given in these cases. My role as the Chief Credit Officer is to review the methodologies and the quality of the ratings.
Do you remember any outside counsel ever investigating anything at Moody's in the past? Anything strike you in terms of a review and whether it was put in writing or not?
I've not been in part of a process of a previous external review.
Well, all right. Sticking to the same sort of seeming penchant for secrecy, Mr. McCleskey, in your letter to the SEC, you said that John Goggins, the general counsel at Moody's, told employees not to put any compliance or rating problems in emails or any other written form. What was your why would he give such instructions, do you think?
Well, sir, the first thing I would say is I didn't have that directly from John Goggins because I had very few conversations with John Goggins at all. Everything came through Michael Caniff. And although Mr. Goggins, the general counsel, was my second-level supervisor, and although he spent considerable time with the other person at my level, in the almost year that I was underneath him, he did not set foot in my office a single time.
Well, irrespective of whether it was Mr. Goggins or not, was it in fact your understanding generally, company-wide, don't put anything in writing?
That was definitely communicated to me.
And why do you think that was generally communicated?
Well, my speculation, sir, would be really going back to the point that was raised earlier. You've got two different imperatives, if you will, between compliance and legal departments that are concerned about liability. In compliance, you need to document when you see a problem. You need to document what you did about it, because if it's not documented, it didn't happen in the eyes of the regulators. So if we would see something, we would want to document it. From a liability point of view, at least theoretically, you don't want to have documents lying around.
Let me ask you, Mr. McCleskey, at any point did superiors at Moody's tell you not to talk to SEC investigators during the SEC sweep investigation?
Nobody ever directed me not to talk to the SEC.
So we do have secrecy, or at least a desire to avoid putting things in writing, whether it be outside reports about fraud allegations or whether it be anything that could be traceable by the SEC, apparently built into the culture. Would that be a fair characterization in your opinion?
Yes, sir.
Mr. Cantor?
I'm sorry, what was the question? That we have secrecy
I guess
culture?
I'm asking you to comment as to whether there's this culture of the avoidance of having anything traceable in writing, even to the extent, as I asked you earlier, about an outside counsel report on an allegation of fraud from Mr. Kulczynski, which, by the way, earlier you assured us was baseless, based on a report that's not completed and not in writing, and then you told us, well, I'm not familiar with why past history or why it might not be in writing. You were confident enough to cite it as exonerating, but not confident enough to talk about the details of whether it's in writing or not.
Well, Moody's conducted its own internal review and reached that conclusion. The preliminary findings of the outside law firm confirms those findings.
Was the Moody's internal review in writing? Is that something you can share with the committee?
I do not. I have not reviewed anything. There may be a document. I don't know.
Well, if you haven't reviewed it,
And-
sir, how can you speak with such confidence before this committee under oath that that internal review can be trusted?
Because I spoke with our head of compliance and regulatory affairs, and he discussed it with me.
I see. My time is up, Mr. Chairman.
Next, gentleman from Florida, Mr. Micah.
Thank you. Just a couple of quick questions. I guess to Mr. I'm going to blow it and I can't see it, Mr. Machinsky. You made a series of allegations about Moody's misconduct, and I believe you're the one that made those allegations in a letter to the SEC. What was the basis of your allegations? How did you? I mean, you saw things that were going on, and then you thought it was your responsibility to report to SEC what you saw going wrong. So, what did you see wrong? At what point? When did you notify the SEC?
Sir, I made my first report was to the compliance group.
I'm sorry?
My first report was to the compliance group. I put into a...
In writing or
in
just
writing.
a
In writing.
notification? Okay.
It was a 14-page memorandum.
And did they respond to you?
They, as far as I know, they hired Kramer Levin and also suspended me.
They what?
They suspended me.
The company suspended you
Yes, sir.
for whistleblowing or for notifying?
That is my belief, yes.
Okay. But did you never got a written response from SEC to this date?
Sir, after I was suspended, I reached out to aware of these violations.
So,
I spoke to them last week, and we're planning on meeting so I can discuss
Okay.
further.
activities. And you talked to compliance and you also wrote to compliance both?
I wrote to compliance.
I'm sorry?
I wrote to compliance.
You wrote, okay.
Yes.
And you never had gotten a response?
As we've discussed in previous, everything was mostly done by phone call. So I received
They
a phone call.
called you in response to your letter?
They called me and they said they're bringing in Kramer Levin, and somebody from Kramer Levin will be in contact with me.
And
All communications from them were verbal. Nothing
so
was
how did Moody's find out about what took place?
I handed Michael Caniff the memo that I wrote.
Okay, Mr. McCluskey, you also reported wrongdoing. Did you report that to the SEC?
Sir, I sent a letter after my departure to the SEC. It is probably
Wait.
going too far.
I'm sorry, for some reason I couldn't hear you. You
I'm
sent
sorry.
a letter
I sent a letter to the SEC after my departure.
after your departure.
Yes, sir. And I don't think I would characterize it as necessarily whistleblowing with respect to wrongdoing. I wanted to flag an issue to them to make sure that they were aware of it when they were preparing to conduct their examinations.
Was your departure voluntary? Or
No, sir.
So they terminated you. Did they cite the cause for which you were terminated?
No, sir. All they did was they said that senior management had lost confidence in me.
Had you had any contact with SEC or any other individuals in reporting activities before the letter that you sent after you departed and were dismissed?
I did not have any contact with the SEC prior to my departure.
Or anyone else who you reported whatever activities you thought should have their attention, should have attention of a regulatory body?
No, sir. I don't think my departure was directly related to any whistleblowing.
Okay. And did you get a response to your comments that you made for attention to SEC after you were terminated and departed?
They sent me an email confirming receipt and said that they were considering what to do about it.
Okay. Do you feel Mr. Cantor, why should the federal government continue to grant Moody's and other big credit rating agencies a protected oligopoly by requiring financial institutions to rely only on your ratings?
Moody's favors the reduction or elimination of the use of ratings and regulation, so we do not favor it.
So you feel that others could be involved in the process?
Yes?
Should you think Congress should regulate that process?
Well, there is currently a draft bill been prepared in Congress to remove the use of ratings in many government legislation and regulations.
How do you think that should be structured? I mean, you don't have to comment on the bill that's before us, but what would be a fair way to have, say, some competitiveness in credit rating, but also keep a high standard of rating?
Right. Well, I think in addition to reducing the regulatory reliance on ratings, the competition, the field of competition in the market could be improved by enhancing the financial disclosures required by issuers of structured finance securities. At present, given the limited disclosure requirements in that market, only rating agencies that have been asked to rate those securities have full access to all the information that might be needed to evaluate the risk of those securities. And we recommend that the SEC require more extensive financial disclosures, much as is required of corporations in America when they issue debt into the capital markets. And that way, multiple rating agencies, not just the rating agencies asked to rate the debt, and multiple analysts from different types of firms can do their own analysis and choose to publish that analysis if they wish to monetize their conclusions or just provide for some other reason that information to the broader marketplace.
Gentleman's time has expired, and I will take 5 minutes. I'm curious, before I ask a question about the compliance group that fascinates me, this internal watchdog. Given the blanket dependence, I would say, of the nation, it's hard to think of an institution, or for that matter, individuals that weren't dependent upon these credit agencies. And given the source of their revenue, has the fall, the collapse of the economy had an effect on the revenue of Moody's, or for that matter, if you know of any of the other rating agencies? Mr. Cantor?
Moody's has had significant decline in revenue over the last 2 years, yes.
Why is that? Is it because people aren't those who fund them, which of course those whom they regulate, as it were, or whom we depend upon them? Is it because they go less often to the rating agencies? Why has the revenue fallen?
We've had fewer requests for ratings.
Sorry?
We've had fewer requests for ratings.
So people are out there on their own.
Well,
There's nobody watching them. If you can say they were watching, there's nobody watching now. People, does that Mr. Do any of the three of you think that shows a lack of confidence in the agencies now, that revenue is fallen and folks don't regard a rating as particularly or at least absolutely indispensable any longer? Mr. Kolchinsky?
I think certainly the confidence in rating agencies has fallen. The drop in revenue is primarily due to drop in revenue from structured products. And I think
due to what? I'm sorry.
The drop in revenue in structured products. Those are the products that like mortgage-backed securities.
Few of those product derivatives, et cetera, to regulate, to talk about, or to grade.
Yes, ma'am. And I think that a lot of that has to do with the fact that at the time of the boom, one structured product would buy another structured product. So ABS CDO would buy subprime, and a Civ would buy some part of the ABS CDO. When that chain broke, that whole market disappeared. So there weren't a lot of what is called in the industry real money investors that were actually buying these products. These were all moved on bank balance sheets or somewhere else into another structured product.
I'm fascinated by this internal watchdog. Internal watchdogs normally do not yield a lot of confidence. And one reason is it's very hard to set up one that can yield confidence. We've tried here in this Congress. How do you get enough outside without too much if you are, in essence, trying to do internal regulation of your own conduct? Mr. Kulczynski, you have indicated or cast doubt upon the independence of Moody's compliance group.
Yes, ma'am.
Why do you believe the compliance group is not independent, and whatever the word independent can mean within those internal watchdog circumstances?
Ma'am, there's several reasons. First of all, I believe a
Speak a little louder into the
Sorry,
microphone, the way
I
I
believe
am.
there's several reasons for that. I believe, first, a truly independent compliance group would report up to the independent members of the board of directors. They would not have a reporting line from the general counsel to the CEO on the business generation. Second of all, I don't...
So they're reporting in the same way they were reporting?
I believe so. I believe so. They're still reporting through the general counsel up to the CEO, and there's no scrutiny of that from the board of directors or
So
at
the
least
same people
independent members
who were reviewing their work are still reviewing their work with whatever lessons the collapse may have taught them.
Yes.
Do you believe that with the same, is it the same chain of command essentially? With the same. Go
It
ahead.
is the same chain of command as I believe when Scott was Mr. McCleskey was at the rating agency. Yes.
So no change in the and I understand the conundrum here. How do you change it? If you're only so many people you can report to, why don't they want? Why? What would be the resistance? Since this is a watchdog, since it doesn't involve matters of ethical matters of the law, you could always ask the general counsel to advise you, Mr. McCleskey, Mr. Cantor. What would be the resistance to reporting to the Board of Trustees, who have a fiduciary obligation, and therefore, it seems to me, are the only really appropriate overseers within the organization?
The individual that's responsible for both compliance and regulatory affairs, so the person in charge of compliance has an additional duty as well to also liaise with our regulators. That person has met regularly with our board of directors, I believe quarterly, and meets with our independent board of directors.
My time, too, is limited. I want to know why, as I say, I would expect him to meet. I would expect the board to consult with him. What reason could a rating agency offer for not having the report unfiltered of a violation go first to the board of directors? Then they could ask general counsel, they could ask outside counsel, they could ask the government. Why, in light of what it seemed to me was the unkindest cut of all, the cut that came from the agencies on whom everybody depended, why isn't the way to restore confidence at least to place responsibility for notification of violations of ethical standards in the law first to the Board of Trustees or to the board, whatever it is called, so that it can decide whom to consult? What's the resistance, and how would anybody justify reporting in the very same way that the chain of command occurred before and that everyone agrees was an ingredient to the collapse of the economy?
If I could respond to that question, because I was the person who was involved in this chain of command. The first distinction I would make is that the person who Mr. Cantor described is not the head of compliance. The head of compliance, as designated on public filings to the SEC, reports to Mr. Caniff. And Mr. Caniff reports to the General Counsel. Now, when I first got to Moody's, we had a different reporting chain, and the idea was that once a year I would report to the board, and the first year I did. After the chain of command changed, I did not have access to the board.
Should you have?
Yes. And to answer your question, what is the motivation for it? I can only speculate, but in my view, having been there in that situation, it's a matter of controlling risk. That you've got somebody there who doesn't come from the litigation background or has this different agenda, the compliance officer. I simply don't believe that it was viewed prudent to have the actual head of compliance have that kind of access.
Prudent. I'm
Right.
just looking for a reason, you know.
It's my speculation, but it's speculation based on my experience.
Yeah. Finally, if one is looking at how to regulate this matter and one is trying to keep the government from getting into the weeds, would you suggest that that a report directly to the board might be one place to begin?
I would, yes.
Requirement of a report to the board might be one place to begin?
I would.
Yes.
Yes, ma'am.
What about you, Mr. Cantor?
A report from compliance directly to the board of directors would be something we would consider. I don't see a difficulty with it.
So what was good enough before is good enough now. Thank you, Mr. Cantor. Mr. Lynch of Massachusetts.
Thank you, Madam Chair. I want to thank the witnesses for helping us with our work. It appears that, at least as this reform proposal moves forward, we're still going to have over-the-counter derivatives traded. The structured products are going to be traded outside of exchanges. And it appears, at least the way this is developing, we're still going to have an issuer pays model after all this reform is done. So we're still going to have the conflict of interest that we've been dealing with in the past. It seems to me that if we're not going to eliminate the conflict of interest in the issuer pays model, then we have to somehow balance that. And at least the only way I can imagine doing that is to introduce some type of liability on the part of rating agencies that stamp AAA on these structured products, because the vast majority of the market, they don't understand deeply the mechanisms of these structured products, but they do understand AAA. They do. And that's what allowed a lot of these projects to go viral and cause problems in the first place. It seems to me that there has to be some type of underlying liability for the rating agency if they slap AAA on something that doesn't deserve it. And right now, the way we have this system, it's tantamount to immunity for the rating agencies, even though they recklessly put AAA on a product that turned into junk 30 days later or 60 days later or 90 days later. Mr. Kolchinsky and Mr. McCluskey and Mr. Cantor, is this a viable option of introducing some liability that might act as a constraint on these rating agencies from giving ratings to these products in return for cash? Because the rating agencies are also going to get extra money. They're going to get a bigger payday for rating these complex structured products than they do the standard products. So how would you suggest that we eliminate this conflict of interest, and is liability one of those options? Mr. Kolchinsky.
Sir, I believe that extra liability should come hand in hand with specific defined standards, and that does two things. On the one hand, it helps investigators and regulators to see when a fraud or misconduct has occurred because they can compare it to a defined set of standards. Today, most of these standards come from the rating agency itself, so the rating agency becomes the judge, jury, and executioner of its own standards. Second of all, having a defined set of standards would cut down on frivolous lawsuits by an investor, for example, who just made a bad decision. So if you have a set of standards for some minimum sets of things that a rating agency must do, that's a good benchmark to see when liability or fraud has actually occurred or other types of negligence. At the same time, it prevents frivolous lawsuits from investors who just made a bad decision.
Yeah. I do agree that it shouldn't be a hair trigger test for liability. Otherwise, you would have everybody who didn't think the instrument performed the way they wanted it to would have a cause of action. We don't want that. Mr. McCluskey?
Well, sir, I would be against any kind of blanket immunity of the type that you're describing. I think that, with respect to the First Amendment protection for rating agencies, I'm not a lawyer, but come on, that's not what the First Amendment was for. Having said that, I would agree that if you are going to introduce more liability, you do need to do it in a measured way with some sort of controls, because we did have difficulties about a decade ago with a lot of frivolous securities lawsuits where, as you say, every time the stock ticked up or down and somebody lost money, off to court we were. So I do see that as a potential danger. But having said that, I'm not a lawyer, but my personal view is that there ought to be some measure of liability.
Thank you. Mr. Cantor?
As we discussed today, Moody's is already subject to liability. We can be sued for fraud and for violation of securities laws. We have a number of lawsuits publicly announced and outstanding. So we already are subject to significant liability. What I think is most important is that there be accountability. And I think there is a fair measure of accountability, certainly in the private market, in the private use of ratings. We're accountable. Our reputation is being constantly reevaluated, and certainly our reputation is being evaluated now. It has always been the focus of Moody's management and its analysts on producing the highest quality ratings and strengthening our reputation to the maximum degree. And the recent experience, if anything, has reinforced that concern and the primacy of that concern in our rating practices.
Thank you. My time has expired. Madam Chair, I yield back.
The gentlewoman from Ohio, Ms. Capter. Oh, okay, let's see.
Thank you very, very much for appearing this morning. May I ask each of you gentlemen to state for the record your professional qualifications? In other words, what your background is. Are you attorneys? Are you mathematicians? We can begin with the first gentleman here.
I have an undergraduate degree in aerospace engineering. I have a law degree and a master's of science in statistics. I've worked in structured finance my entire career.
Thank you very much.
I have a PhD in economics. I taught economics for a number of years at the universities, and I worked for 10 years in the Federal Reserve System and have been at Moody's for 12 years.
Okay, Mr. Cantor, thank you. And what about Mr. McCluskey?
I have a master's degree in financial regulation and compliance management. I also have a master's degree in international relations from Cambridge, where my dissertation concerned financial regulation. I've been in the markets in the United States and Europe for approximately 15 years. I participated in the drafting of regulations, and I've got several published articles and books on the subject.
All right. Are any of you gentlemen familiar with the term in the law, control fraud? You are not. Well, if you're not familiar with it, then if you've been a part of it, you wouldn't know it, I guess, if you don't even know the term.
Can you repeat the term again?
Control fraud.
I'm not familiar with it, no.
Control fraud is systemic fraud, in which it goes beyond a single person, but the person participates in a system that is essentially fraudulent, and as a participant in that system causes a great deal of harm and participates in illegal activity. Let me ask you, as the housing bubble burst and foreclosures increased, mortgage-backed securities issued began by mortgage brokers began to crumble despite the AAA ratings that Moody's and others had placed on these issuances. As you look back on this, with all of your education and experience, how could you participate in rating, particularly the senior tranches that had AAA ratings, that collapsed? How is this possible? Would you please explain that? We can start, each one of you. What happened, Mr. Kloczynski?
I think the main part of the problem were poor incentives everywhere across the board.
Poor incentives?
Poor incentives. You had mortgage
define
brokers.
that.
You had mortgage brokers who were incentivized to get as many mortgages as possible without any concern for the credit quality. They would be paid upon closing of the mortgage.
Yes, but the rating you gave them very favorable ratings, AAA ratings. So the paper was brought to you. I'm asking you, though, in terms of how could you have been a participant in your company, a participant in a system that collapsed? Don't blame those that brought it to you. Once you got it, what did you do?
I think we over-relied on quantitative models.
On quantitative models. I wanted to ask you, for Moody's, how many people actually worked for Moody's prior to the collapse of the market?
I don't have that information offhand.
What would you guess? Anybody want
My
to?
guess is about 3,000, 3 to 4,000.
Yeah, 2,000 maybe in the rating
2,000?
agency.
Do you say?
In the rating agency itself, 2,000.
Could you speak it in the microphone, sir, please?
2,000, I believe. Could
About
be more.
2,000 people. Okay, how many of those people then would you, of the 2,000, Mr. Kloczynski, your job was managing director. You were the head of it all?
No, ma'am. I ran, I was one
Of
of
the
four managing
investors.
directors, one of the four managing directors within the CDO group. And we had about 100 people total within that group.
About 100 people. Were these the people that were the mathematical brains that ascertained risk?
Some were mathematicians. We had a lot of PhDs. We had a lot of lawyers. People came from across the board. But that was part of the group which decided methodologies, built the models, and ran the models.
All right. So, in other words, they made big mistakes.
Yes, ma'am.
All right. And so it wasn't just that the mortgage brokers brought this paper to you, but there was a system set up. And explain to me internally inside your company what happened in that risk division that was so faulty. What happened and why did it happen?
I think the system that existed in place allowed bankers and other participants to game the models that were set up. The models are actually very public, and what participants could do, could look at the models and change.
When you say model, are you talking mathematical model?
Yes, mathematical models as put into an actual spreadsheet or a piece of software or even a methodology. In my group, in the ABS CDO group, and CDOs in general, those models were actually publicly available. Some were free to download from the website. But that allowed bankers and other participants to game those models.
But who approved those models?
The gentlewoman's time has expired. I ask unanimous consent to give her an additional 1 minute.
I thank the gentleman. Who approved those models? Who invented the models and who approved them?
It was different groups and people who were tasked with that. Most of them internally were based on data that was provided to Moody's.
Did you approve them?
I did not approve any specific one model.
Who approved them? Somebody above your pay grade?
In some cases, it was above my pay grade because I wasn't in a position
Can you give
yet,
me a list
but,
of who approved them?
Ma'am, I would know. It was done by the committee, and usually...
Which committee?
By a committee set up for a particular methodology. So there's a...
Under your
No,
watch?
not under my
Above you?
specific. It would be some cases above me, some cases below me, but there was no standard process of model review and approval during the credit crisis.
Let me just, in closing, Mr. Chairman, I wanted to ask Mr. McCluskey, you were the Chief Compliance Officer?
Yes, I was.
Okay, the SEC did an examination of Moody's in, what was it, 2006, 2007, something back?
I believe
Then-
2007.
How long did you meet with them as Chief Compliance Officer?
How long did I meet with them?
Yes.
I did not meet with them.
They did not,
They did not meet with me.
you were the Chief Compliance Officer and the SEC did not meet with you?
That's correct. They met with our legal department and outside counsel. And I did
That's a
object.
shocking statement.
I did object to that.
Thank you, Mr. Chairman.
Right, thank you very much. And now yield 5 minutes to the gentleman from Maryland, Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Chairman, I wasn't going to ask any questions, but listening to Ms. Captor's questions, I was just curious. Could not help when I heard that when she was asking about this fraud, and she went on to ask questions concerning why all of this happened, and I think you said something about insufficient incentives. Did somebody say that, Mr. Kuczynski?
Yes, sir. I believe.
And can you help me with that? Explain that to me with all my constituents losing their houses, losing their savings, losing everything they've got. We hear about people on Wall Street getting these phenomenal bonuses. And I mean, when I heard those words, I almost fell out of my chair. I was trying to eat my lunch. And I had to come and ask you a question about that. Can you help me with that? Are they making, do we have some people making a little bit of money on Wall Street? Is that it?
No, obviously, people on Wall Street
Make a lot of money
Yes, sir.
while messing over the American people. Big time. Now tell me, just explain to me, because my constituents want to know, when you say a lot of this happened because of insufficient incentives,
Poor incentives.
what does that mean?
Because for the most part, most people in the securitization chain were not paid based on the long-term performance of the product they originated. So a mortgage broker was paid at the closing of the mortgage, not depending on how that mortgage did. The mortgage originator, like a Countrywide or a New Century, was paid when they sold the mortgages to an aggregator bank, like a Lehman Brothers or a Merrill Lynch. They were paid right there and then, not depending on how the mortgage was performed. The bank then structured those mortgages. The bankers were paid on the closing of the deal, not on depending on how the security performed. And that security went to an ABS CDO.
So in other words, it was like selling a piece of zero, I started to use another word, and calling it something more valuable than what it is, pass it on like a hot potato. At some point, somebody's going to have to pay, and the American people paid by being thrown out of their houses and losing their savings and what have you. Is that right? Is that right?
Yes.
Yeah, and then they were also put in a position where what you're saying is that they were being paid for quantity and not quality. Is that right?
That is correct.
And, I mean, if you were, say, Secretary Geithner, what advice would you give to the President of the United States? Because I can tell you there are a lot of people in my district who are mad. And they are wondering whether or not we are doing the things that we need to do to straighten out this mess, but not only to straighten it out, but to make sure it does not happen again. And I want you to just look straight ahead. There's probably a camera facing you right now, as if you're talking to the President of the United States, and say, Mr. President, this is what I would do. This is how you correct this mess. This is how you make it so that we don't have to go through this again. This is so that Mr. Cummings will not be coming before me, telling him about all of the things that his constituents have suffered through and continue to suffer through, and how they have been robbed of their savings, robbed of their futures, robbed of their houses. Tell him. Tell the President. He's watching.
Well, sir, I would recommend that alignment of incentives across the board would probably be by far the best solution. And that is actually a return to the old roots of Wall Street, where there used to be a term called eat what you kill, and that meant somebody only takes home whatever they actually produce and whatever money that they bring in. And my recommendation would be that people who work in complex products and structured products retain a vertical slice of whatever they produce. And hopefully that would align their incentives, that their eventual pay and whatever they take home is based on whatever they produce. So the mortgage broker would get paid based on the mortgage. If that mortgage didn't pay in the first payment, then they wouldn't originate. They would know that that's a bad investment. And same on down the line. Countrywide, New Century, Lehman, Merrill Lynch, and all those bankers, they would not put the taxpayers at risk because they were putting their own livelihood at risk.
Did you have something, Mr. Brzezinski?
No, sir.
Okay. Thank you very much, Mr. Chairman.
Thank you. Thank you. I yield a minute to the gentleman from Indiana.
Reinforcing the gentlelady from Ohio and the gentleman from Maryland's point, salespeople to some degree sell. And yes, it would be nice if they had long term. The check was supposed to be you. You're the rating agency. If you knew, obviously, that they had a motive to sell, that there was no back check, the back check is supposed to be the rating agencies. You're supposed to say what they sold wasn't real. And instead we had the hedge fund people figuring out and telling us that they figured out it wasn't real. They made money betting against your ratings. And that is what we're trying to figure out how to address here, because in the market, yes, some people are sellers, other people are supposed to be long-term, but if the rating agencies are in cahoots with the sellers, there's no public backstop. And now everybody's turning to government because the private sector didn't perform the function. And her questioning was along the lines of, where were you all? Now, we're going to have some testimony from an attorney, Mr. Abrams, who says that you didn't perform an investigative function. You took basically the word of the management, and you basically said a similar thing, that they're reporting to you, and instead of doing, and American people think you're an investigative agency. They think you're doing an independent investigation, not just taking a pass on from the companies. And so you weren't the check to the sales part, and that's part of our frustration.
Right. No, they were saying that if you pay us, then we rate it. I mean, all you have to do is just pay us. I mean, that's basically what happened here. So let me thank all of you for your testimony, and say to you, Mr. Cantor, we would appreciate if you would help us get the documents. We would like that very, very much, and because, as we look at the overall meltdown, that our interest and concern is to try to make certain that it does not happen again. And in order to do that, you could be very, very helpful in that process. Thank you very, very much for coming. Thank you, Mr. Krutinsky. Thank you, Mr. McCleskey. Thank you, Mr. Cantor. Thank you very, very much. Right.
Thank you.
Now we move to the second panel. I'm good. I'm good. I would like to welcome our second panel. As with the first panel, it is committee policy that all witnesses are sworn in. So if you would please stand and raise your right hand while I administer the oath. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? If so, answer in the affirmative. Right. May be seated. Let the record reflect that all witnesses answered in the affirmative. Let me begin by introducing our witnesses. Senator Alphonse D'Amato served as a New York senator for 18 years. During his Senate career, Alphonse D'Amato served as the chairman of the Senate Banking Committee and was also a member of the Senate Appropriations Committee and the Senate Finance Committee. Since leaving Congress, Senator D'Amato has founded a public policy firm called Park Strategies. Good to see you, and happy to know there's life after you leave this place. Right. Mr. Floyd Abrams is a nationally recognized First Amendment lawyer. Over his long career, Mr. Abrams has represented a wide variety of clients, including the Brooklyn Museum of Arts, the New York Times, Time Magazine, Senator Mitch McConnell, AIG, and most recently, Standard & Poor's. Welcome. Mr. Eric Backinson is a Senior Investment Officer of Global Equity for the California Public Employees Retirement System. He is responsible for implementation and management of investment strategy and policy for the pension fund, a $132 billion portfolio in publicly traded equity investments worldwide under his current leadership. The Global Equity Unit also oversees CalPERS, corporate governance, hedge fund, domestic long, short cash management, and manager development programs, and the ongoing restructuring of the asset class that began last year. Welcome. Dr. Lawrence White is a professor of economics and the deputy chair of the economic department at New York University, Stern School of Business. Dr. White has also served as a board member for the Federal Home Loan Board and as the director of the Economic Policy Office in the Antitrust Division at the Department of Justice. Before joining the Stern School, Dr. White was a member of the President's Council of Economic Advisors during the Carter administration. Welcome. At this time, I ask that each witness deliver their statement within 5 minutes. And of course, you know the procedure. The yellow light comes on, which means you have a minute remaining. And after that, then it becomes the red light, and that means stop. Now, I've been having some problems with the members of the committee recognizing red today, because the point is that it's such an interesting topic, and of course, they're trying to get to the bottom of it because so many people have been hurt as a result of what has gone on with this meltdown. So we will start with you, Senator D'Amato. Good to see you.
Thank you, Mr. Chairman. First of all, Mr. Chairman, let me congratulate you for holding this hearing. It's important because I feel very strongly that the failure of the system and the credit rating agencies in particular contributed substantially to the economic chaos that hit this country. The small homeowners, business owners, and right across. Mr. Chairman, credit rating agencies began their lives providing an important and very legitimate investment tool, and it allowed investors to evaluate securities. But once the system changed to one where issuers pay for the agencies to rate their securities, the stage was really set for trouble. And there have been a number of members today who have raised that issue. And if you want to cut through it all, that's the problem with the system. Issuers are paying the rating agency, and the rating agencies are looking the other way. Why? You've had two young men testify today And I dare say they lost their jobs and were fired unfairly because they dared sound an alarm. And the higher-ups didn't like it. And the fellow who testified for Moody's today, that was a debacle. He didn't know anything. He just knew that they try to do good ratings. You have one person who was a chief compliance officer. They finally adopted things that he had recommended. In the interim, they said, well, you didn't get along, and they dumped him out. By the way, he wasn't the traditional whistleblower, and he came in here only after the committee invited him. And I dare say Mr. Kulinski, his colleague, somewhat naively thought that if he brought certain matters to the attention of the people that he should have, that they would have responded, and they did. They threw him out. And the SEC did not investigate until 1 week ago after you held these hearings. Shame on the SEC. Shame on them. It's like putting the lamb guarding the tiger's den. That's what's been going on. And at long last, they finally came out with a list of recommendations. At long last. And I think that this committee and the Financial Services Committee should examine them because they are meritorious. But one that is most important and should be acted upon, and they have the ability, and Congress has the ability to do so, is the SEC's proposed prohibition against letting a rating agency act as both a rater and a paid advisor for securities issuers. This dual capacity is one that unavoidably creates conflicts of interest. And don't buy this firewall nonsense. It doesn't work. And the American people have a right to be protected. Mr. Chairman, I've spent some time discussing this matter with the prestigious Financial Economics Roundtable, and they have a number of methodologies that they suggest. And I'm going to ask that their testimony that we have submitted, that their statement be placed in the record as if read in its entirety.
Without objection, so ordered.
Mr. Chairman, let me go on to say that reference was made to the debacle that took place at Enron and that took place in corporate America. And things were done to deal with that. That doesn't mean we have a perfect system today, but you did have an analogy that was striking in terms of conflicts, and it undermines the credibility of organizations that people are dependent upon. Our accounting industry was subverted for a while when you had accountants, the big three, the big four, who were not only auditing, but being paid as advisors. We stopped that. You can't be an advisor today to a public company and be an auditor. And that's as it should be. Because inherently there is a conflict to both being an advisor and an auditor. And Mr. Chairman and members of the committee, that inherent conflict of interest exists today. And all this business about, let me tell you, every one of the big three rating agencies tell you they want competition. First of all, there is no competition, really. They enjoy 90% of it. They've got the stamp of approval from the SEC. And the way to really provide competition and get the most modern methodologies involved today, and there is a way to do that, is to see to it that there's a ban on issuers being paid or paying rating agencies. It's rather simplistic, but that's where we should start, and that's the nub of the problem. Thank you, Mr. Chairman.
Thank you very much for your testimony, Senator D'Amato. Mr. Abrams.
Good morning. Thank you very much for inviting me. Mr. Chairman, Mr. Ranking Member, I'd like to say first, it's good to have Senator D'Amato back in town. We all miss him. I come from New York, so I can say that freely. I'm appearing on my own behalf today because I was asked by the committee to come, which is to say I was not designated by my client to come. But I do want you to know that I represent Standard & Poor's and have and represented them for over 20 years, and I've represented the McGraw-Hill Company, their parent, for over 20 years.
But I'm impressed with you representing the Brooklyn Library.
Yeah. So I'm here to talk, at least in the first instance, about the issue of liability and the questions and issues raised in part by the new discussion draft released by Representative Ken Jarsky, because I thought that I could add something from the fact that I represent Standard & Poor's in now over 30 litigations commenced around the country after and as a result of the economic collapse that has occurred. Those litigations are of lots of different sorts, under lots of different statutes, federal, state, and common law theories. The proposal before Congress now, at least in the discussion draft, is to amend the 1934 Securities Act, which is a fraud statute. And I come here to urge you to try to see that three principles are adhered to if you should amend that act. The first is that we should adhere to the core principle of the act that currently exists, the 1934 Act, which is liability for knowing or reckless misconduct, as distinct from allegedly negligent misconduct. Not what's argued by someone to be unreasonable, but by doing something in bad faith, intentionally, on purpose. Mr. Krasinski, who sat in Senator D'Amato's seat a few minutes ago, had the legal test right when he articulated to you what he thought the test was. If a rating agency or anyone else issues a rating or does something in the securities field where they're saying something they don't believe in, that they either know or think is false, if they do that, they can be held liable. And my view is that you ought to continue to adhere to that standard, whatever else you do. The second thing I think you should do is to treat every defendant equally. Rating agencies should not be singled out so that they wind up in a situation where if a rating agency, an accounting firm, and a securities analyst are in the same case, you have different legal standards applied to the three of them. They should be the same legal standards, whatever they are. And the third is that whatever you do, you ought to do something which is as pro-competitive as possible. And what I mean by that is that there are proposals now in the discussion draft, for example, which I consider extraordinarily anti-competitive. There's a proposal, for example, which would say in so many words that rating agencies have to share all the information they gather with all the other NRSROs that exist to investigate everything that comes in from all those other rating agencies, to review them, and to be liable if another rating agency does something which is against the law. This is what the draft statute calls joint liability. I think that's not a good idea. I don't think it's fair. I don't think it's deserved. I also know it's uninsurable. And I ask, who's going to go into this business? Who are the new NRSROs going to be if you enact legislation of that sort? So I conclude then with the notion that with those principles outstanding, you can change the statute if you think it's necessary to do so. I can assure you on personal knowledge, there's lots of litigation against rating agencies in the multi-billions of dollars going on right now. Thank you, Your Honor.
Thank you very, very much for your testimony, Mr. Abrams. Mr. Bagginson.
Yes, good afternoon, Mr. Chairman. Thank you very much for inviting me here and all the rest of the committee members for hearing CalPERS' voice and perspective on this issue. My name is Eric Bagginson. I'm the Senior Investment Officer for Global Equity, which also incorporates our corporate governance activities at CalPERS. We see the rating agency issue as one of governance. That's the reason that I'm here. This is not simply about fixed income instruments. CalPERS is the largest state pension fund in the United States. We manage approximately $200 billion currently for 1.6 billion members, million members, not billion, not yet. We definitely rely on the quality and the integrity of market information, and credit ratings are an important portion of that information set. There's a public interest in ensuring that the information disseminated to investors is reliable, that the providers of the information are free from conflicts, and that there's accountability, transparency, and proper oversight of the delivery and the development of that information set. There are three components of information that we find critical to making investment decisions and positioning our investment portfolio. The first of those is financial information, constituting financial statements. Those financial statements are attested to by auditors. The next is governance type information, where companies give us information about the activities of the organization in their prospectuses and the activities they have planned for the organization. And a third component of information is creditworthiness. The first two of these, financial statements and governance information, are held to high standards of accountability and are highly regulated. The third, credit ratings, fall into a never-never land. They are not in the same category of integrity as the first two. If any of these components of information are weak and unreliable, that weakens the entire financial system. There are a number of entities that have attempted to quantify the impact of credit losses in the recent market dislocations that have happened over the last 2 years. And these figures currently run into the trillions of dollars. The credit rating agencies certainly had a role in that activity. Part of the market dislocation that we experienced potentially can be laid at the feet of rapidly shifting perspectives as to the creditworthiness of various entities that existed in the marketplace. When you go from a highly rated entity to an entity that is virtually bankrupt overnight, that creates a huge amount of risk in the system, and that rolled through every aspect of the financial marketplace. CalPERS uses credit ratings in a number of different ways. The most prevalent area where we have credit ratings are in our policy documents that guide how we structure our investment portfolios. Credit ratings are an integral part of that activity. They reflect the degree of risk-taking and return expectations that we have relative to a number of segments of our investment portfolio. Another area where these things impact CalPERS is the aspect that credit ratings are embedded in many of the market indices. As we engage in asset allocation activities, we look at market indices to tell us what is the risk and return profile of different investment categories. Credit ratings are an integral part of that, particularly in the fixed income arena. In the third area, credit ratings are used to control the risk-taking of outside investment managers. So we will oftentimes specify certain types of securities indicated by credit ratings as being applicable to outside managers. Certainly our fixed income portfolios make use of credit ratings as well as their own research and activities. The credit rating agencies have a position where they have access to sets of information that we do not have in our own research activities at CalPERS. And to the extent in our global equity portfolio, we have approximately 10,000 different securities contained within that portfolio globally. Many of those issuers are dependent on the attachment of a credit rating to allow them to access the capital markets as they execute their capital raising activities. And the very last area that I see us using credit ratings is in the area of performance attribution. It helps us understand and disentangle whether investment managers are making money for CalPERS based on taking credit risk, whether they're taking duration risk, all of the other different attributes that can be used in that. So there are a number of places that these things intersect with CalPERS's activities. The organization has a number of proposals or concepts that they think will help you as you move forward with attempting to address these issues. We do believe that the compensation model is a problem. We certainly support the SEC's actions. We support a stronger SEC. We think that that organization is charged with investor protection. We see no other comparable organization. The agency should have high-level compliance staff. They also need to have accountability and responsibility for the actions and the results that stem from their activities in the marketplace. And at that, I will stop and invite your questions.
Thank you very much for your testimony. Professor White.
Mr. Chairman, Chairman Towns, Ranking Member Issa, and members of the committee. My name is Lawrence J. White. I'm a professor of economics at the NYU Stern School of Business and a member of the Financial Markets Working Group at the Mercatus Center at George Mason University. During 1986 to 1989, I served as a board member on the Federal Home Loan Bank Board. I represent solely myself at this hearing. Thank you for the opportunity to testify today on this important topic. The three large U.S.-based credit rating agencies, Moody's, Standard & Poor's, and Fitch, and their excessively optimistic ratings of subprime residential mortgage-backed securities in the middle years of this decade played a central role in the financial debacle of the past 2 years. Given this context in history, it is understandable that there would be strong political sentiment, as expressed in the recent proposals by the Obama administration, as well as other proposed legislation and recent rulemaking by the SEC, for more extensive regulation of the credit rating agencies in hopes of forestalling future such debacles. The advocates of such regulation want, figuratively, to grab the rating agencies by the lapels, to shake them and shout, "Do a better job." This urge for greater regulation is understandable and well-intentioned, but it is misguided and potentially quite harmful. The heightened regulation of the rating agencies is likely to discourage entry, rigidify a specified set of structures and procedures, and discourage innovation in new ways of gathering and assessing information, new technologies, new methodologies, new models, including new business models, and may well not achieve the goal of inducing better ratings from the agencies. Ironically, it will also likely create a protective barrier around the incumbent rating agencies and is thus likely to make them even more central. There is a better route. That route starts with the recognition that the centrality of the three major rating agencies for the bond information process has been mandated by more regulation of banks and other financial institutions. In essence, regulatory speculative bonds, as determined by the rating agency's ratings, has imbued these third-party judgments about the creditworthiness of bonds with the force of law. This problem was compounded when the SEC created the category of Nationally Recognized Statistical Rating Organization, NRSRO, in 1975 and subsequently became a barrier to entry into the rating business. As of year-end 2000, there were only 3 NRSROs, Moody's, Standard & Poor's, and Fitch. It should therefore come as no surprise that when this literal handful of rating firms stumbled badly in their excessively optimistic ratings of the subprime RMBS, the consequences were quite serious. This recognition of the long-standing role of financial regulation in forcing the centrality of major rating agencies then leads to an alternative prescription. Eliminate regulatory reliance on ratings, eliminate the ratings force of law, and bring market forces to bear. Since the bond markets are primarily institutional markets and not a retail securities market where retail customers are likely to need more help, market forces can be expected to work, and the detailed regulation that has been proposed would be unnecessary. Indeed, if regulatory reliance on ratings were eliminated, the entire NRSRO structure could be dismantled and the NRSRO category could be eliminated. This could well make the incumbent rating agencies less important for the future. The regulatory requirements that prudentially regulated financial institutions must maintain safe bond portfolios should remain in force. but the burden should be placed directly on the regulated institutions to demonstrate and justify to their regulators that their bond portfolios are safe and appropriate, either by doing the research themselves or by relying on third-party advisors. Since financial institutions could then call upon a wider array of sources of advice on the safety of their bond portfolios, the bond information market would be opened to innovation and entry in ways that have not been possible since the 1930s. Thank you again for the opportunity to testify today. I would be happy to answer questions from the committee.
Thank you very much. Let me thank all of you for your testimony. You know, we talked earlier with Mr. Cantor. He doesn't feel that they played a role in this meltdown. But I want you to know that our role here today is to try to find ways and methods to fix what's going on. And, of course, I want to start with you, Senator D'Amato, and, of course, Mr. Baggeson, probably all of you, as to what can we do to prevent credit rating agencies from contributing to the next financial collapse. What can we do? Why don't we just go right in?
Mr. Chairman, Professor White did touch on a number of things, and they can get a little bit esoteric, but the fact is that once we stamped NRSO on those three agencies, and I think there's one other now, the Moody's, the Fitch, Standard & Poor's, and one other, we gave them a headlock. We kept out competition, innovation, that the market forces are very capable of providing. So I think there's a lot to what we can do. And I'll come back to beat the dead horse. How do you keep honest people honest? You have the fence or the wall or the prohibition. You do it one way or the other. I think the fence and the wall are half-hearted attempts, and you're always going to find, I mean, here you saw this fellow McCleskey who was in charge of compliance, and they moved him right out. You're still going to have those kinds of things. You want to keep honest people honest. An issuer should not be paying, or put it the other way around, the rating agencies should not be paid by an issuer for a particular issue. The two are incompatible. You saw that situation in the accounting problems. It is the same here, and I think that is one of the important elements, and I think the SEC finally has it right in their proposed recommendation. That should be adopted, and we should open the system up to competition, and Professor White touched on some methodologies that can and should be employed.
Right. You know, I get your point, because even in research with doctors and with patients, they finally had to come up with patients that were involved in the research to have their own doctors, because the person that was involved in research, the only thing he was doing or she was doing was looking at their research and not at the patient, how the patient was doing. So I get your point very, very well there, Senator. Let me just, any other comments there?
Yes,
Mr. Abrams, yes.
If I may. My reaction is twofold. First, one of the problems here is that there's been too much reliance on rating agencies, as if they were the only source of information, which they've never been, as if that was the place to go. CalPERS, by way of example, is suing my client, so I'm very interested in CalPERS, and I'm glad to sit next to the gentleman here who I may depose someday.
Well, we'll arrange this.
And for over $1 billion, by the way. Let me read you one line from CalPERS' complaint in that case. It says, other than the rating agency's evaluation and subsequent credit rating of an SIV, a special investment vehicle, an investor had no access to any information on which to base a judgment of an SIV's creditworthiness. My reaction is that if that is the case, and I don't want to argue our case, if that were the case, they shouldn't be investing in the sort of entities where they know nothing other than its rating. And I think in general, there has been an over-reliance on ratings only. One of the things I know that my client has been trying to do since the bad events of the last few years is to try to get out the story a little bit better about what ratings are and what they're not, that they're essentially an assessment of creditworthiness in the future, the likelihood of repayment down the road, not of market value, not of volatility, not of liquidity, not of a lot of things which will ultimately and even short-term affect pricing. But it's not easy to get that story out, and I think one of the things that has to be done is for a much better public understanding of just what ratings are and what they're not.
So you're saying that the SEC should play a greater role in this process? I mean, I'm not sure I
think there are things the SEC can do. Indeed, I think the SEC can play a role in helping to restore credibility, if you will, of this whole process, particularly if we are moving in the direction of more competition. We have 10 NRSROs now. As Senator D'Amato said, not so long ago we had 3, 4, 5. Now we have 10 since and because of the act passed by Congress in 1966, the Credit Rating Reform Act, which took effect in 2006, which took effect in 2007. If we're going to open this up and have more and more and more NRSROs, or perhaps, as Professor White says, not have NRSROs anymore, we'll still need a significant level of oversight by the SEC, and some of their proposals in that respect are in the direction, I think, of helping the industry to be better viewed because, again, with all these entities in now and more to come, you're taking entities which may not always be of the highest level in terms of experience and making them NRSROs. The SEC used to say you can't be an NRSRO because you haven't had experience. And the argument against that was how can we get experience? And we need the designation, et cetera. All right, we went in the direction then of saying we will give the stamp, so to speak, of NRSRO to, I don't want to say almost any, but any financially secure entity, even if they don't have a lot of past experience. There's a societal risk in that. I think it was a good decision, but there's a risk-reward in it. And one of the consequences of doing that is that I think you need a higher level of SEC involvement, so long at least as you have the NRSRO designation in the first place.
Right. And you, gentleman from California, my time has expired.
Thank you, Mr. Chairman. Mr. Abrams, under Sarbanes-Oxley, we looked at the auditing world and the big 10, 9, 8, 7, 6, 5, 4 accounting firms, and we found that in fact they were playing two sides of the game. They were doing the annual audited financial, and then they were selling a bunch of products, and the two basically could not have firewalls. They simply couldn't get past the fact that partners all benefited effectively from that and if there wasn't money in one side and there was money in the other side, the partners wanted to share or they didn't want to be on the other side. So Congress made a decision that we could no longer have that. In the case of rating agencies, do you believe that we should consider narrowing what 1 or 3, 5, 10, whatever amount of rating agencies can do versus other services so as to make it as close to the equivalent of your annual audit rather than a more broad set of opinions and products being sold? Do you think that would help?
Two thoughts. One is I think the notion of saying that rating agencies shouldn't do consulting, say.
That's exactly what I'm saying.
Yeah, I understand. Is an appropriate one. My understanding is my client doesn't do consulting, but without getting into definitional issues, the notion of separating consulting as such from ratings, I think, is a wise one. But that said, I think you really do have to take care about how far you go in terms of limiting.
Well, let's take it for a moment in a direction that Professor White would take it. If I look at stocks rather than bonds or other debt instruments, if I look at stocks, if Goldman Sachs wants to take me public, they take me public, and everybody understands that they're making a market, they're making a lot of money, they got a lot of fees, they're making my portfolio, their portfolio for me look as good as possible. Basically, they're finding ways in a legal way to kite the stock's value to the highest possible level for the public offering, and then they set it a little less than that so it pops on day one. We all understand that. However, if 5 other institutions begin tracking my stock, they're tracking it much more independently. And that is the difference between who takes me public and who, in fact, is giving their clients advice. Is that model, and I'll go to Professor White, I think, part of where the direction we need to go. We need to recognize that those who look at the papers and present an opinion are very different than those who provide an opinion on an ongoing basis for the value of something. And I'd like to go to Professor White, perhaps, to see, when you look at the obsolescence of the existing model, should we end it in favor of something with more transparency and a number of rating organizations for the protection of CalPERS and others, or should we try to mend the existing system?
Congressman, the existing model that I would abandon is the regulatory reliance on ratings. That's the crucial thing. That's where everything else follows. Once we get rid of that, and it's, the SEC has taken some initial steps. We need bank regulators to do the same, pension fund regulators, insurance regulators. The Congress can legislate in this direction. Once that's done, remember, this is an institutional market, and bond managers at pension funds, at banks, at insurance companies, at money market mutual funds should be and can be expected to exercise judgment about who is a trusted source of information.
Well,
and they can look at the business model of an advisor and say, I'm not so good with that.
And I've got one person with $200 billion at stake here. Mr. Bageson, in your case, if we move to a model where obviously somebody's going to put the wrapper together initially, but instead of relying either on that rating organization or, Lord help us, on AIG to wrap it in a AAA rating, which often was the problem, wouldn't you be better served if, in fact, that model were in place because you're a sophisticated buyer, but you don't have enough to do a full analysis, perhaps, in the old model without relying too heavily on the rating agency?
Yeah, there are a number of areas where the current model breaks down. These things have been addressed, for example, in the auditing profession. You're well aware of that. That is one possible alternative, is to move down that kind of a structure. Certainly another structure is to remove the regulatory reliance. That's another alternative. There is no, in the equity world that I'm most familiar with, there is no requirement, for example, that I look at Goldman Sachs stock rating before I purchase a security. That's, or to put it in a particular type of a portfolio. That does not exist in the equity world in that area.
And you invest in the equity world on an informed basis.
Absolutely. Absolutely. The credit rating agencies, currently, we are almost required, again, by my naive judgment, in respect to Mr. Abrams wanting to oppose me potentially later, but I believe that
we'll try it later, not here.
We are almost required to look at those ratings simply because the credit rating agencies are allowed access to inside information that we do not have access to. So if we did not consider that information, we would certainly potentially be ignoring another pool of information, and that in itself could cause problems. So there are a number of different structures to this. If you take away the accessibility of inside information to credit rating agencies and make them the equivalent of any other security analyst or whatever you care to out there, that certainly changes the degree of reliance that we would be able to place or would be willing to place on that pool of activity. That is definitely a way to mitigate against the power and the leverage that these organizations have.
And my time has expired. I just want to sort of bring to a focus your statement. So if you had all the same information that the credit agencies had as a sophisticated investor, a large sophisticated investor, you wouldn't even be having this potential day in court if you had all the same information. That at the heart of it, you had to rely on something you didn't know that he did know.
Conceptually, sir, but recognize there are hundreds of thousands of credit instruments out there. So the scale of this industry makes it almost impossible for any enterprise, even one the size of CalPERS, to go in and dissect every possible issuer, and so on and so forth. So there are some resource limitations to that, even in the presence of a place
Sure,
like
we understand
CalPERS.
that, we rely on Google when we put in a word, and we don't necessarily get it all. But in this case, you believe you were denied access to the same information, and therefore you relied on it both regulatory-wise and because they're given information you're not.
Yes, sir.
Thank you.
Right. Thank you very much. The gentleman's time has expired. I now call on the gentleman from Maryland, Mr. Elijah Cummings.
Thank you very much. I want to put all this into some kind of context. Mr. Baggeson, I think the point for all of us to remember is that CalPERS and other public pension systems is that they manage the retirement and security for a lot of our constituents. I mean, you do it for California, I assume, but for teachers, bus drivers, policemen, other public servants, and those pensions are funded with public tax dollars, and losses, however they may occur, cost taxpayers money. Is that right?
That would ultimately be correct, sir. We recognize that our pension beneficiaries, we do not see it being in any risk in this issue. But it's certainly, if we lose money or make less in return on our portfolios, the contribution rates that roll back to taxpayers could have to increase, certainly.
Yeah, that's the point I was trying to make. And I know for a fact, having been a former in the Red Book and a bond counsel before I came to Congress, that I remember when I first started doing bond work, and they talked about Moody's and Fitch, and what they said, Fitch, and they said, the rating of a bond agency you can rely on because it's like God talking. That's exactly what they told me. And now I realize that, maybe they were overrating the bond agencies. And that brings me to the point of, you didn't have much of a choice as to whether or not to use the credit rating agencies. Is that right, Mr. Baggeson?
Well,
and what else are you going to do?
Well, that's exactly right. Their activities are enshrined in market practice and regulation throughout the marketplace. Throughout the marketplace, sir, their activities are rife throughout it, whether it's regulatory requirement, historic practice, whatever you care to.
And so your own investment policies determine the portfolio's risk in the bond ratings. Is that correct?
Yes, sir. If you think enshrined again in our policies, there are references to the amount of risk that we are willing to take within certain segments of our investment portfolio. That risk is often expressed in the terms of a rating. Those ratings have been held out historically as the yardstick by which to judge creditworthiness.
And you didn't say this, but the fact is that in talking to a member of my staff who used to be involved in looking at how Baltimore invests its pension money, he told me that they would often look at CalPERS to see what kind of things that you all were doing. I know you didn't say this, but because you all were seen to be so good at it, and of course you had you're dealing with, 200 million people, and they figured that if you all were doing something, they might want to at least take a look at it, because you all, whether you admit it or not, became sort of a gold standard. And your gold standard, I guess, was based largely on information that you were getting from these rating agencies. Is that a fair statement?
The information from the rating agencies is absolutely incorporated in everything CalPERS does. The degree of reliance is something, I guess, that we'll explore probably in a courtroom.
Had you decided at some point that you could no longer trust the bond ratings being issued, what were your options, if any?
The option is to try to do the research yourself, and that becomes extremely obviously labor-intensive, resource-intensive, and very expensive.
And almost impossible, is that right?
Well, the scale of the marketplace is so large that we certainly don't have a staff. We have 40 people in our fixed income area.
Now, could you have disregarded those ratings without risking suits for breach of fiduciary duties? In other words, it's already a part. You're looking at a rating and you don't rely on it. I mean, what happens then?
Well, for example, I'll go back to the example of the benchmarks that we use in order to execute our asset allocation work to determine where we deploy capital in the portfolio. Credit ratings are enshrined in a portion of that benchmark exercise. The fixed income indices all are rated by, are these investment grade debts, are these junk bonds, all different kinds of implied ratings attached to that. That has an effect, those benchmarks have an effect on how you deploy your capital as you match your capital deployment to the liability stream that we're trying to meet the needs of with the pension fund. So certainly the activity and the presence of those ratings and their use in the marketplace have had impacts on how we allocate capital. That's inescapable.
If I might just ask one quick follow-up, and that is, that as a result of all of this, finding out all of this information, how has that affected, if at all, your business? I mean, it's from what you have learned about what the rating agencies may have failed to do.
Well, again, from the perspective of what I do on behalf of CalPERS, this looks like a very familiar governance problem. This is the same problem that was dealt with back in the days of Sarbanes-Oxley with auditors and all the rest of that. I mean, so this is a very similar governance issue, and it's providing, obviously, a huge array of work for us in trying to figure out how to accommodate and how to compensate for that. So even now, our fixed income portfolios, for example, if we are not able to farm capital out to external managers, where those external managers are being controlled by being constrained to investing in certain rated securities or certain tiers of securities, if we cannot rely on those managers to be able to really understand the risks attached to those securities, that causes us to have to bring capital back internally to manage, which we may or may not have the resources to do. So there's a whole raft of effects on our business model that are stemming from this activity.
Thank you, Mr. Chairman.
Thank you very much. We promised to have the senator out by 1:30, so Senator, we recognize...
Mr. Chairman, I have the clock is ticking, and I've got a point to catch.
Yes.
I commend you again for the hearings.
Thank you very, very much.
Thank you, Mr.
Pleasure. Right. We now yield 5 minutes to the gentlewoman from Ohio.
Oh.
I'm sorry. You're here. I didn't realize you were here. Okay, I'm sorry. The gentleman from Indiana, they changed up on me here, Mr. Souter.
No, I understood. I've switched. There's a big temptation to go off on a higher level challenge about how bubbles work, because in fact, like we talked about Enron, the dot-com bubble, back to tulips in Holland, it's like mark-to-market. You go too much and then you contract too much, and it's the challenge of how to keep an even flow. But one of the fundamental questions that comes every time we go through one of these in world history is who's actually doing the investigating? And one of the questions, one of the bankers from Meyer, who's on Federal Reserve, sat down with me early on as we were going through TARP and TALF and so on, and said one of the challenges here was that basically the housing market went up by 400%. The growth was going up 25%. So how did people miss the bubble? And that one of the challenges, any of you, in other words, how did Moody's, how did the investment firms, how did the banks? Because once you sit back and go, well, there's going to be a housing bubble whenever you have, just like in the dot-coms or a run-up in energy, in historical, looking back on it, you can see it. But sometimes you want to say on this one, it was pretty evident. Now, I want to probe a little bit with Mr. Avon's testimony, because we had lots of good testimony here. But most people thought that bond ratings were investigating. But the implications of your talking about what's a reasonable verification, reasonable investigation in your written testimony, and what, in fact, bond entities, your rating agencies, do, that underneath this, if you're mandated, if the firms are, and I realize you're not officially representing them today, but if these firms are to look at the underlying capital, in other words, does this firm have enough capital, wouldn't that require investigation into whether some basic assumptions like did the housing market grow 400% in where the economy was only going 25, in securitization, that the different tranches, the more far out you went in the tranches, the more risk you were taking, and doesn't that require investigation to do a capital requirement?
Well, my understanding is this, that Standard & Poor's, at least, has conducted a loan-by-loan investigation through its computerized analytic efforts, which I don't begin to understand personally, but it is loan by loan. But it does presuppose that when they receive information from the entities that supply it to them, the information itself is accurate. Then they deal with the information. Now,
May I interrupt for a second?
Yes,
I think
please.
in your written testimony you said that, for example, it required assuming in forecasting, because Standards & Poor's isn't a forecasting organization, that the management forecast were reasonable. But isn't that assuming that the entity that you're about to rate is, in fact, giving you a forecast that's accurate rather than going and looking back at the housing market to determine whether their forecast was accurate? Because otherwise the capital assumption's wrong.
Now, look, Standard & Poor's has economists. Their job is to do the best job they can in forecasting internally in a way that helps them how the housing market and other markets are going to do. They gather information, lots and lots of information, which bears on it. They come to assumptions based on history which goes back to the Great Depression. And they did that, and they did it with respect to the housing market, and they presupposed that the housing market was going to go down. I mean, it isn't so that they thought that it was going to keep going up. They thought it would go down, and they worked with models based on historic experience to try to tell them how much it could rationally, predictably be said to go down, and that wasn't enough. It went down much more and much more quickly. I'm sorry.
AIG, I mean, from our time, I mean, it was a house of cards that it appears that nobody really investigated. If I could go to Mr. Baggeson for a second, when you say that you can't afford enough investigators, I mean, I think your investors assume you're doing it. What you're really saying is it would cost you more money and reduce the return to your investors if you hired a bunch more investigators. Isn't that correct? If you hired 80 investigators, it would lower your rate of return. And part of the problem here is everybody wants a high rate of return, so everybody starts chasing, hoping that they can get this high rate of return. Nobody really wants to check, because if you only offer 4% and somebody else is offering 12, then your holders will complain. And that's how it spread to the whole economy, because everybody started going into speculative stocks, because if you didn't buy housing tranches and securitization, if you didn't buy pharmaceuticals and you didn't buy energy, you couldn't get higher than a 4 to 6, because 4 to 6 was what the economy was growing. So anything you were getting up here was pretty speculative, yet nobody really wanted to dig in, and everybody goes, well, we didn't do the kind of core investigation. We were just relying on the statistics, and based on past models, we thought it might go down a little, but not this much. Yeah, but nobody got in and looked at the core. And that's what's hard to understand. Everybody, the consumer didn't, the agencies that were placing the consumers' dollars, the different companies, insurance companies, started speculating more than they would have in order to be able to compete to get money into insurance policies. And it's like somewhere in here, we have to have somebody looking at the core, not just circulating information, or we'll repeat it.
Gentleman's time has expired. And now you have 5 minutes from the gentlewoman from Ohio.
I thank the chairman for the time and inviting this excellent group of panelists this morning and this afternoon. Let me say that, Mr. Abrams, I wanted to ask for the record, in what community is your law firm located?
I'm sorry, in what?
In what community is your
I'm sorry.
law firm?
New York City.
You are in New York City.
Yes.
I've noticed, as a Midwesterner, the coastal nature of most of our witnesses. And therefore, from the heartland, I have to send this message. The first is that going back to the 1980s, the abuse that occurred in the savings and loan system was followed by an even greater set of abuses we're experiencing today, because what Congress did back then, and I served back then, sent the wrong message. It sent the message that if you abuse the financial system, the taxpayers would bail you out. And it's been done again to a much greater degree. If I look at the current situation today and how it affects my region, just so the folks from the coast know this, Ohio has now lost an additional money center bank. PNC, whose vice president, Mr. Demchak, invented the derivative when he worked for J.P. Morgan up there in New York, moves to Pittsburgh. And one of the results of this debacle has been we have made the big banks bigger, and places like Ohio, now we only have 3 money center banks left. National City was bought by PNC. We look at which banks are failing. 126 of them, I guess, have been resolved at this point at the FDIC, and we see the big banks getting bigger. I think 3 rating services isn't enough. That's an oligopoly, the way I look at it, all right, out from the heartland. Maybe folks in the coast look at it a different way. I'm just putting this on the record. The result of this system of housing rescue has been that now the federal government is the dump basket for all the mistakes of the private sector. The large banks have essentially taken profits and socialized losses. Just look at FHA. If we look at our federal mortgage instrumentalities, we used to hold 1 of 50 mortgages. Guess what? We now hold 1 of 4. Because all the toxic assets have been dumped on the public. And what worries me most is that what's going to happen again, because of the power of these institutions, is that we're going to open the floodgates more. I don't know how much more damage they can do than they've done already. But here's what I want, and this is going to be my question to you. As you see the financial reform proceeding, whatever that reform is, over in some of these committees, here's what I want. Tell me how close we're going to get from what you've seen is occurring over in the Financial Services Committee to it. I want a safe and sound banking system again. I want more than financial services. I want a banking system again. I want a healthy housing market. I want the re-empowerment of community capital accumulation versus the movement of that capital to just a few money center institutions. How close am I going to get to the re-empowerment of community capital accumulation? And how close am I going to come to the restoration of prudent lending and responsible savings? Based on what you've heard is occurring here, you heard the President's speech, you talked to your colleagues up there in New York. I asked Mr. Bernanke, and I'll end with this statement. Mr. Bernanke, you know, we're under the Cleveland Fed. And the Cleveland Fed sort of has something to say about what the New York Fed does, but not really. Would you be for the democratization of the Fed, where every single region has an equal vote? You know what his answer was? Absolutely not. So, my question to you is, based on what you've heard, how close are we coming, under these reform proposals, to a safe and sound banking system, a healthier housing market, the empowerment of community capital accumulation versus money center bank capital accumulation, and prudent lending and savings in this country again?
I'll go first because I can be very brief on this because it is so far from my area of expertise. But speaking for myself, I think a number of the proposals will move us significantly in the direction that you want, including a number that the President has proposed. But to get where you want to wind up is going to take a lot of doing.
Yes, it is.
That's a very difficult question. From the capital market perspective, we think that many of the reforms that have been proposed are certainly encouraging. Things like proxy access, there's a whole raft of governance things that have been proposed under the, I would say, the new SEC, which seems to be reinvigorated at its job as a protector of investor interests. So we're very encouraged by those actions. It has yet to translate into real differences in the behavior of the marketplace. You've laid out a number of attributes here that it's not clear to me how much of this can be commanded by a regulatory system. In many cases, what you're asking
Excuse me, Mr. Mayor, I just interject there. It isn't just the regulatory system, which is the track we're on. It's the architecture of the entire system.
Excellent point. But you cannot, I don't think that you can turn the clock back, for example, if capital formation and people are moving from, for example, from Ohio to California, you're not going to turn back the influence that migrates, let's say, to California, in other words, from Ohio, so that, you know, people in the dynamics of how they live and where they choose to live and what they choose to do are going to have a large impact on the relative influence of the different regions of the United States. So
I hear what you're saying, but I mean, we want to have strong community lending. We want rigor and prudent lending to be possible again, and it won't be. It won't be unless everyone has a piece of the action. And you just can't sell risk up the chain that then ends up being dumped on the federal government. And my concern is we're going to be off into consumer agencies and a little tinkering here with regulatory, and we're missing the big picture. I can remember the day, and my time has expired, and Professor, I would love for you to answer my questions to the record, by the way, when they came down to the banking committee and they took the name off the door. It used to be Banking, Housing, and Urban Affairs. That's when we had a real, that's what was left of a real banking system, what was left of a sound housing market, and what was left of a real commitment to our community, to our urban areas across this country. What we've ended up with is financial services. The name says it all. We have to go back on top. We are down here in the middle. We have to go back to the architecture, and my greatest fear is we're not going to get there, and we'll end up with an even bigger crisis because the architecture will be wrong, and just dealing with regulation won't be enough. Thank you very much, Mr. Chairman.
Right. Thank you very much. And let me just, in closing, you know, I'm still having problems with this conflict of interest. You know, if you rating agencies paid to help structure securities, they then get paid to rate the same securities. I'm telling you, that to me sounds like a conflict of interest. So I'm still having that problem. You know, Winston Churchill, just for you, did the ranking member have anything else you'd like to add?
Mr. Chairman, I just want to thank you for this, this hearing. I think in closing, it certainly has shed light on the fact that we're not going to mend this system without significant change, and I commend you for doing comprehensive, and I hope to be more comprehensive, review of all the causes of the financial meltdown. And yield back.
Right. Thank you very much. And let me close by saying Winston Churchill once described Soviet Russia as a riddle wrapped in a mystery inside an enigma. After listening to today's testimony, I think he could just as easily have said that about the way credit rating agencies operate. Today we had testimony from two former senior employees at Moody's who described a culture of secrecy, a place where putting things in writing was frowned upon. Can you imagine working at a place where the very act of writing a memo or sending an email is a suspect? This culture of secrecy extended to companies outside Moody's as well. Moody's tells us they retain an outside law firm, Kramer Levin, to investigate Mr. Koczynski's allegations of illegal conduct at Moody's. But this morning, we learned that this outside firm was given an oral instructions, only oral instructions. Moody's says there is no written statement of work and no contract specifying the work to be done. In addition, this outside firm is not expected to produce any written report of its findings and has no schedule of completion. On top of that, Kramer-Levin says this is their normal behavior. They never produce written reports. Instead, they give their clients oral briefings. In other words, the Moody's business model could be summed up as leave no fingerprints. Don't ask, don't tell. This might be all right if the credit rating agencies hadn't played a starring role in the collapse of the financial system. For that reason, this cannot continue. It's very clear to me at this point that effective legislation is needed along with effective oversight to bring about the confidence that is needed to be able to turn things around. The testimony we've heard today is just the opening chapter of what promises to be a sordid story. We intend to pursue this further. Finally, I want to thank all of our witnesses, and I want to thank the two witnesses, Mr. Kolchinsky and Mr. McCleskey, who had the courage to come forward to testify about what they saw at Moody's. Now, I am aware that testifying before Congress is never easy. And we want you to know that we appreciate their participation, and also we appreciate the participation of all the witnesses. On that note, without anything further to do, the committee stands adjourned.
Thank you, Mr. Chairman.
It's good to meet you.
Nice to meet you, too. Nice to see you again, Floyd.
Good to see you.
As always. As always.
You too. Sorry about last